Hi, my name is Robert Shelley, and I'm an attorney that assists physicians in getting better employment contracts without getting taken advantage of by their employer. Physician non-competes are always a huge part of any contract negotiation. It's usually one of the most important things to the physician. So a non-compete basically states that the physician cannot work in their specialty for a certain period of time within a certain geographic limitation. And so I get asked very often, is a 10-mile non-compete considered reasonable or enforceable? The short answer is yes. In almost every state, 10 miles from your primary practice location would be considered reasonable and enforceable. There are a few states where physician non-competes are completely unenforceable, but there aren't many of them. And then every state kind of has their own either case law or statutes, which would hold what would be considered reasonable and enforceable. If you're working in a rural environment, most courts would find that a larger geographic restriction would be reasonable. If you're working in a big city, like in New York City or Chicago or LA, 1 mile could knock out a huge portion of the population, and that might be considered unreasonable. It honestly just depends. But for the average physician in the average town, 10 miles from your primary practice location would be considered reasonable and enforceable. Sometimes the employer will try to sneak in there that applies to every location of the employer, or maybe even every facility that the physician works in if they're doing clinic work and some inpatient stuff. But this is just a key point of every contract negotiation. What will the physician be prohibited from doing when the contract ends? That's just a normal part of every physician contract. We've created a cheat sheet that's in the description below that you can download. And if you have any questions, feel free to contact my office. Take care.